Hello everyone. So, beginning with Unit 5, Chapter 3. Adoption. Adoption is the act of establishing a person as parent to one who is not in fact or in law his child. In fact means in actual. He has not given birth to that child. And in law means that legally he is not his child, biologically and legally. What is the difference between the two? That is, you say the legal heirs of a person, right? So what is it? As per law, the blood relations or the ties by marriage, they are said to be the legal heirs, right? So as per the blood relation, he is not his child. That means by law he is not his child, and in fact that is in actual also, he has not given birth to the child biologically. He is not the parent. Okay, so in fact, or the word or is used, so any of the two may be fulfilled. ठीक है. सो अडॉप्शन मीन्स एवरीबडी नोज आई थिंक द बेसिक ऑफ इट कि वो उसके असली माँ बाप नहीं है, लेकिन बिकॉज दे वर इन द नीड ऑफ अ चाइल्ड और द चाइल्ड वॉज इन नीड ऑफ पेरेंट्स, राइट? सो either ways, for the benefit of both of them, the relationship can go. So a legal relationship, and it is a legal process, so it is a relationship created by law. That's why we say that adoption is a legal relationship established between the parent and child who are not related biologically, defined as a process by which people take a child who was not born to them and raise him or her as a member of their family. So after adoption, since a legal relationship is created between them, so even if that person or the child was not related anyhow to those parents or to those couple, but after the date of adoption, they will be considered to be the parents, and the child will have all the rights as a biological son of the couple would have. Okay, so now adopted child के पास वो सारे inheritance या as a child of the parent, वो सारे right होंगे as if he would have actually born to them. Okay, so that means raise him as a member of the family. So now the child will also get the name of the parents who have adopted him, and he will be as a member of their family and has to be treated as such. Okay, and also he has to be given name of the family, and because that only will be done as treatment of the family, because अगर वो उनका सच का बेटा होता तो उसको अपना नाम देते ना, right? So there has to be no difference, and it would be as if he is the real child or the biological child, because the rights which he will be inheriting from the parents after adoption, that is same as a biological child would have got. Okay, earlier, the objective of adoption was to secure performance of funeral rites and preserve the continuance of one's lineage. As I told you, maybe that a couple is not able to bear the child. कुछ मेडिकल इमरजेंसी है या मेडिकल इन्फर्मिटी है, बिकॉज ऑफ विच दे आर नॉट एबल टू बियर अ चाइल्ड, बट दे वॉन्ट देयर जनरेशन टू कंटिन्यू. पहले के टाइम पे तो प्रॉब्लम ही इसी का रहता था, दैट अब हमारा वंश कौन आगे बढ़ाएगा. इवन जब बेटी पैदा हो जाए तब भी ये रहता था, राइट? सो द कंटिन्यूएंस ऑफ वंस लाइनेज मीन्स टू कंटिन्यू द जनरेशन, and the performance of funeral rites, because when the person dies there should be someone left, or there should be someone surviving him or her who will perform the funeral rites of that person, right? So that's why also the adoption can be done. Okay, so basically ये जो funeral rites वाला भी है, that is also done by the biological son only, है ना? तो biological son वाला right adopted child को दे रहे हैं ना, so that is what I have said also. Statutes governing adoption. The Hindu Adoption and Maintenance Act. So what are the statutes in India that govern and that regulate the adoption? And since the statutes are which govern the adoption, that's why it is said to be a legal provision. The Hindu Adoption and Maintenance Act 1956, which is the only statute, and the ambit is confined to Hindus. क्योंकि Hindu adoption है, तो it is confined only to the Hindus. The law codifies the legal process of adopting children by a Hindu adult and legal obligations to provide maintenance to the various family members. So we are not concerned with the maintenance to other family members right now. We are only concerned with the adoption, which is given under this act, and the procedure for that also is given. And since it applies only to Hindus, so it states the process for adopting children by a Hindu adult or a Hindu couple to be precise. Fine. Law on adoption for other religions. There is no law in Christians, Parsis, and Muslims. A person belonging to these communities has to get himself appointed as guardian under the Guardians Wards Act 1890, which applies to all communities and castes. So here nothing Hindu Muslim is prescribed, so that means this Guardians and Wards Act applies to all communities and castes, even to Hindus also. So here Guardians and Wards Act means guardian of the ward. So by the court they will be appointed as the guardian, these communities. Fine. And for Hindus, they can always come to the specified act for the purpose that they are already having. The court will take into consideration the personal law of the minor, क्योंकि वो adopt किया जा रहा है, उसकी life, see, the life of the minor will be at stake because he is not going to live with someone who are his biological parents, but to complete stranger. तो हमें नहीं पता that how will he be treated. Right, and since he is a minor, so he has to be taken due care of, right, all the basic amenities and that innocence to keep alive. ऐसा ना हो कि वो उसको साथ ले जाकर टॉर्चर करें उसके साथ या कुछ गलत काम करें. So that protection of the minor also has to be ensured. So वो सारे circumstances देखने के बाद ही कोर्ट किसी को गार्डियन अपॉइंट करता है, because protection of that minor is at stake and we have to protect that future. Okay, so the court takes into consideration the personal law of the minor also, कि वो minor किस religion का है, उसके law में क्या prescribed है and all that stuff, while appointing or declaring someone as a guardian. Once a person is appointed, he has to abide by the provisions. ठीक है, he is appointed under the act, so now he has to abide by the provisions and perform the obligations thereon. Minor custody and guardianship. Minor, you know, guardian means a person who has rights and duties with respect to care and control of a minor in relation to body or property. Body means to the physical body of the person, the mental and physical well-being, and property is the estate. हो सकता है कि उसके पेरेंट्स उसके नाम कुछ प्रॉपर्टी करके गए, या बिकॉज द पेरेंट्स डाइड इन अ नेचुरल कैलामिटी, सो द प्रॉपर्टी ऑटोमेटिकली केम डाउन एज पार्ट ऑफ इनहेरिटेंस, or the minor inherited that property of the parents, right? Or there may be some joint account of the parent and the child, but parents died, so now it belongs to the minor alone, right? And he can get the money after he attains majority, so that can be property. These rights of guardian include the right to determine the child's upbringing in regard to religion, education, other matters such as disposal of properties. So right of guardian means the thing that he has to do. Now since guardian means who will guard the person, right? So guard means to take care and to control all of the minor's affairs, to provide him with the basic amenities, to take care of him, to provide him with the protection. And since minor is not capable of taking decisions, right, his consent is immaterial for that matter, so to take decisions on his behalf also. Okay, and that can be to determine the child's upbringing, कि वो कहाँ पढ़ेगा, किसके साथ बैठेगा, किसके साथ रहेगा, कौन से रूम में रहेगा, right? What will be his living standard, what all books and all that stuff, and what will be his religion, because generally क्या होता है कि जो भी पेरेंट्स का रिलीजन है वही बच्चे का रिलीजन बन जाता है, right? So that all has to be taken into consideration. That's why also the court even it considers कि चाइल्ड का क्या रिलीजन है और इस गार्डियन को अपॉइंट किया जा सकता है या नहीं, who may belong to the same or different religion as that of the child. Okay, and other matters like disposal of property. Of course, if the minor has some property is in his name, तो वो कैसे dispose of होगी, उसका consent, उसकी decision भी तो guardian ही लेगा. So that are his rights. And the duty is to act for the welfare of the minor, because जो minor हम आपके जिम्मेदारी पर दे रहे हैं, आपको उसका ख्याल रखना है. That has to be protected. The welfare of the child is paramount, as I have told you. In matters of custody and guardianship, every community has its own laws. The Guardianship and Wards Act, which is a non-religious, that is universally applicable law to all the religions, to all the communities regarding issues relating to guardianship of a child. This was passed during the British period. वो तो जो ईयर लिखा है उसी से समझ में आ रहा होगा. This has authorized the court to appoint guardian for a minor. The child may belong to any community. It is a universal act, so it applies universally to guardians and wards both. That means the guardian may be of any religion and the ward, that is the child जो कि ward बनेगा उन guardians का, he may also be of any community or religion. Hindu Minority and Guardianship Act, again, it is something which belongs to or governs only the Hindu community, and it is a codified law. So, as it is said that every religion has its own law that governs guardianship, but they are not codified. लेकिन Hindu law codified है, and for such matter we have Hindu Minority and Guardianship Act. According to this, guardian includes a natural guardian, that is, he may be related by some family relations or family ties. Guardian appointed by the will of minor's father or mother before their death. They may have appointed someone that मेरी मरने के बाद तुम इसका देखभाल करना, right? And a guardian appointed by a court. So it can be, first of all, natural guardian, that may be the parents, or that can be the mother or father in situations like if it is an illegitimate child of the couple, तो उसका natural guardian mother को समझा जाता है, ठीक है. And if there is no mother or father who may be the natural guardian, then they may have appointed someone, तो वो हो जाएगा, क्योंकि mother father would have chosen the best for their child, no? So according to that, whatever their will or their wish was, that will be considered. And even वो भी नहीं है तो फिर court, that is the last resort. De jure and de facto guardians. Now de jure means something or an authority vested by law, and de facto means by fact, which is already there or which is established. Fact means to hai, sun rises from the east, that is a fact, that is an established rule, right? So de facto means power without being legally established. De jure means a guardian which is authority vested by law, means a de jure guardian जिस पे authority to be the guardian and to take the decisions on behalf of the minor, that authority is vested by law. Such guardian will be de jure. And de facto means he is exercising the power without being legally established. That means not legally or by law, by court he is being appointed, but as a guardian he is exercising his powers or rights. ओके, सो दैट कैन बी द नेचुरल गार्डियंस. ऑफ कोर्स हमने किसी कोर्ट में जाकर तो पेरेंट्स नहीं बोलते ना दैट, और द कोर्ट्स डज नॉट अपॉइंट्स एनी पेरेंट व्हेन द चाइल्ड इज़ बॉर्न कि हाँ चलो कोर्ट जाएं, अपने आप को अपॉइंट करवा के लाएं एज गार्डियंस. नो, there is no need of that, right? So they exercise the power without being legally established as the natural guardians, because that is a fact which is already established. Okay, what are the de jure guardians? Natural guardians by birth, father and mother, as I told you. Testamentary means by testament, and testament means a will. So by will, suppose किसी father या mother ने ही एक will में अपनी death के पहले एक will बनाई कि मेरी इच्छा ये है, मेरी death के बाद this person looks after my child because it is in the best interest of the child. Okay, so that will has to be executed considering the last wish of the parent. So that can be the person executing the will, means the said person who is mentioned in the will, when he performs the rights and duties of the guardian, then he is said to be a testamentary guardian, means a person who acts as the guardian as per the testament or will which was made. Certificated means guardians appointed by the court under the Guardians and Wards Act. Okay, the natural guardian of a Hindu minor, section 6 of the act provides that natural guardian of a Hindu minor boy or unmarried girl in respect of minor's person and property is the father. Okay, so generally the natural guardian is father in respect of his body and property, and after him mother, only after him, ठीक है, उनके बाद ही mother होगी, ठीक है. So पहले तो father ही है. Here the term after means in the absence of. That means if the father has died, then there is only the mother who has to take care of the child. So she will be the natural guardian. Ordinarily, when the custody battles जब होते हैं कोर्ट में of a minor child below the age of 5 years, the general rule is that the best care can be taken by the mother. ठीक है, so custody battles इसीलिए ज़्यादातर mothers जीत जाती हैं. So you see the conflict, little bit of conflict, that natural guardian we always consider to be a father. In absence of him only the mother will be considered. But when it comes to taking care of or the custody of a child who is below the age of 5 years, then always the best interest is considered to be of the mother. फाइन, ऐसा नहीं है कि फादर अच्छे नहीं हो सकते या वो देखभाल नहीं कर सकते, बट समटाइम्स टू केटर टू द नीड्स ऑफ सच एन इन्फेंट इज ऑलवेज द प्रेफरेंस इज गिवन टू द मदर. ओके, एंड कस्टडी मीन्स कि वो उनके कंट्रोल में है, मतलब कि वो उनके साथ रह रहा है, इनके प्रेजेंस में रह रहा है. फाइन. A functional guardian, a person who is looking after the welfare of the child, actually taking care of him. Functional means who is actually functioning, who is actually taking care of the child. ठीक है, कस्टडी हमने मदर को दे दी, बट मदर जॉब पे जाती है, तो घर पे कौन रह रहा है, उसकी नानी रह रही है फॉर सपोज, तो ही that so she may be called the functional guardian, means who's actually looking after the child, will be given responsibility. It is immaterial whether that person is a father or mother. The paramount consideration is welfare of the child. So this is most important. Then Muslim law, Muslims do not recognize mother as a guardian, whether natural or otherwise. So in Hindu law, mother is the natural guardian, बट आफ्टर फादर. लेकिन यहाँ पर तो मदर को बोला ही नहीं गया है, वेदर नेचुरल और अदरवाइज शी कैन नॉट बी अ गार्डियन, but she has the right of हिजानत, which is the right of mother to have custody during early childhood. ठीक, तो उतना right है, that is same as Hindus. A guardian appointed by will is testamentary. Under the Hindu Minority and Guardianship Act, both parents can appoint a testamentary guardian for the child. Position under Muslim law, it is not so among Muslims. In Muslim law, only father has power to appoint a testamentary guardian. Mother has no such power. Since mother cannot be a natural guardian or otherwise, so she also does not has the power to write in her will that after my death, or after if something happens to me, I'm not able to take care of the child, then this or this person will take care of the child. तो ऐसा कुछ पावर मदर की नहीं है. So that is the basic point of distinction between Hindu law and Muslim law regarding custody and guardianship of the minor child. So hereby this chapter is also completed. Thank you so much.